So the Supreme Court has issued some fairly controversial opinions over the last couple of years on everything from religious freedom to affirmative action. And in response, I've seen a lot of political risk analysts issue what are basically histrionic reports in response. So those of us in the security space, I think, need to better understand the tension between the judiciary and the other branches of government and what a conservative Supreme Court means when it comes to how your corporations or clients will respond to the rulings that are issued. For those who are unfamiliar with how the American judicial system works, we need to start with the concept of stare decisis, which is just the fancy lawyer way of saying that judges make decisions based on precedent. This is also called the common law, which we inherited from England when they were our colonial rulers. Now, the US has diverged significantly from England when it comes to the common law because we developed our own. But judges, especially Supreme Court justices, issue their opinions based on previous precedent. They don't just issue their rulings by fiat. So decisions have to build upon each other. Now, that's important to understand when analyzing a conservative Supreme Court because they're still going to be bound by the various precedents for the most part. However, the US system, stemming from our Constitution, believes in checks and balances. And that means there's an independent judiciary. And with an independent judiciary, which is very important for Republican theory on government, stemming from Polybius and Montesquieu, the Supreme Court very much can act as a check on the power of both the executive and legislative branches and the state governments post 14th Amendment. So the Supreme Court can't do necessarily whatever they want, but they are an independent check on the other branches based on their interpretation of stare decisis or the common law. The reason we're talking about a conservative Supreme Court is because we haven't really had one since the 1930s. Now, the 1930s was actually a really contentious time between the judiciary and the executive. President Roosevelt was responding to the Great Depression by greatly expanding the role and power of the federal government. And the Supreme Court kept issuing checks and undoing what he was trying to implement. Now, FDR got tired of this and tried a political tactic called packing the court. This backfired for him in the 1938 elections, but it ultimately tamed the court, as we kind of think and say about it. And the court began very much moving away from a conservative, or what we might refer to as originalist or textualist interpretations of the Constitution and law, and greatly expanded the power of the federal government, and then expanded things like civil rights and civil liberties. This especially happened under the Warren Court, which was from 1953 to 1969. Some of our most important constitutional decisions come from this period. Say Griswold, that established the right to privacy, or Brown v. Board of Education, that helped end segregation, or Loving v. Virginia, that helped overturn miscegenation laws, anti-miscegenation laws. So we are not used to having an independent conservative judiciary. When it comes to analyzing a conservative Supreme Court, you really have to start with the general framework of analysis that the justices will use to interpret the cases before them or precedents. For conservatives, this generally means originalism, which means that the justices will look at the original definitions of the words used in the Constitution or the laws passed by Congress, rather than assuming that changing definitions over time can be applied, or quote unquote the spirit of the law or the intended aspect of the law. They actually go to the text and what the words mean. Now, just because two justices are originalists doesn't mean they're going to interpret the law the same way either. For example, Hugo Black gave a lot of quote unquote liberal opinions, even though he was an originalist because he took the words of the Constitution seriously. So analysts need to really dive in and understand originalism or other interpretations of the law in order to forecast cases. I highly recommend reading the work of Anson and Scalia, Robert Bork, or the Heritage Foundation if you're interested in understanding the conservative or originalist perspective. Now, once analysts have this understanding of the framework, and then particular justices, so for example, John Roberts is more of an institutionalist than an originalist, they'll be able to forecast how those justices will impose an opinion in the court. Now, we can lay out the six conservative justices that we have, and you'll need to understand the nuances of their belief system. in order to be able to forecast particular cases or broad trends on the court. Related to this, you also need to know the values and interests of your corporation. So, a conservative court won't necessarily harm or cause political risk for your corporation or your client, but it also could, depending on their particular values or interests. In sort of an ironic twist, certain regulatory issues at a conservative court will likely greatly benefit corporations, but because of the more left wing leaning of a lot of corporations, social issues, civil rights, civil liberties, the court may actually harm the particular values of the company. So, broadly speaking, your political risk analysts are going to need to know the ideology, the framework of analysis for the justices themselves, but then you also very much need to understand the interests and values of your corporations and clients and how particular cases or trends would impact them. In doing this, you'll be able to forecast in a better way and analyze in a more practical way the possible political risks of a conservative court on your client and customers.